I'm curious to ask what you think the odds are going into the final chapter of Guilty, Not Guilty.
You got to have guilty, not guilty, and hung jury.
We'll add the last one in there, I suppose. Yeah, how do you see the percentage breakdown?
Probably 90-0-10.
All right, it's all come down to this. The SBF trial wrapping up, and back with us is the former lead prosecutor against Bernie Madoff, Marc Litt. Thanks again for hopping on with us, sir.
Thanks for having me.
We talked about all of the things that we would see from the prosecution and SBF's legal team heading into the trial. You called most of everything right when we chatted back then. It's been 4 weeks or so now. We've heard closing arguments from both sides. And you kind of highlighted for us, Marc, what we should expect and how this case was going to go. I'm curious just to get your take, I guess, on how it's played out relative to what we chatted, about back then, and what you think as the jury begins to deliberate.
Well, I think it played out pretty much as expected. It's a standard white-collar securities fraud case, and they follow somewhat standard rhythms and story arcs, and this one followed it. I guess some of the things that stood out based on press reporting mainly is that the defense was not able to do much at all with any of the cooperators. And in part, that was the reason why I think the defendant decided to testify, which was always a possibility and maybe even a likelihood given his personality. But, if a defendant thinks that they're ahead when it comes to the time to actually make the decision about whether to testify or not, they generally don't testify if they think they're ahead. And by ahead, I mean that they're telling from body language or something that one juror at least is on their side, or if they think they've made compelling headway against all the cooperators and have a shot at convincing the entire jury. If a defendant is ahead, they're not going to take the risks that come with testifying. In this case, I think they thought they were behind. He testified, and as we talked about pre-trial, he was subjected to some cross-examination, including a lot of which related to prior statements that he had made publicly, whether to the press, to Congress, to investors. And looking at one of the risks is that prosecutors then use that testimony and use his body language and use his what they allege is his evasiveness and the difference between how he did on direct and how he did on cross, and highlight that to the jury, which is something they obviously couldn't do if he hadn't testified.
Yeah, I had him down pretty substantially as well, heading into him taking the stand. I think everyone watching this play out basically came to the same realization, was they had no other defense other than Sam getting up there and saying what he didn't know. But I'm curious kind of if that, in your eyes, maybe backfired, because the prosecution made a lot of him saying, I do not recall, more than 140 times by their count in cross-examination. I mean, does that ever backfire on like what a jury sees in terms of maybe potentially purposefully saying you don't remember what happened?
Sure. I mean, the difference between his rehearsed direct examination and his inability to handle the cross-examination is telling, and something that you would naturally expect the prosecutors to highlight, and jurors take note of it.
When it comes to, I guess, how long you expect the jurors to deliberate on this, we were talking about if they get the case, how long it takes could dictate to which side they're leaning. I don't know what your expectations are. We talked about Elizabeth Holmes and maybe how long that was as a corollary, as an example to point to. What do you make of, I guess, any early insights into how the jury might be leaning?
Well, I don't have any insights into how the jury might be leaning. I can tell you that in a case like this, a quick verdict is likely a conviction. So by quick, I mean today, tomorrow if the jury sits on Friday. Um, if there's a verdict returned, I would bet good money that it's a conviction if it's quick. If it stretches out into next week, um, you would have to stretch pretty late into the week before I would say there's a possibility of a hung jury, meaning, after Wednesday, Thursday, then you start, and there would be jury notes by that point that
Hmm.
people can start to read tea leaves about. Um, but, there are a lot of charges to go through, and, the jurors will want to be careful and go through the instructions and the evidence and each of the charges and take the time to discuss each one of them.
Yep.
So, 3 hours of deliberation, I would say, is about the minimum for a case like this. The maximum before I'd start thinking that there was a hung jury or even potentially an acquittal, although I'm dubious that would happen, is more like a week.
All right. So if we go
Uh, you
across a week, we'll be looking at. We'll call you again, I suppose, is what we'll do if we go past a week. But I kind of want to get your take and your grade on things, because when we first sat down and looked at the defense and what they would have to do in order to kind of get to an eventual acquittal, you had mentioned that confusing the jury by adding a bunch of, jargon and complexity in all of this and what they should be weighing, margin trading, blah blah blah. They try to do that. They also, as we discussed before, would have to undermine the testimony of the three co-conspirators. I don't think they did that very well. You also had to complicate, I suppose, not just what Sam did, but also what he knew at the time. And then the last one was try and present a lack of criminal intent. And when you kind of look at what's played out in this trial, I'm curious what your take is on how good or bad Sam's defense team did in executing that strategy, because from where I sat, it was pretty terrible across the board.
Well, I mean, look, it's hard to judge because you don't know. A defense lawyer plays the cards that they're dealt. So the real question is, how did they do relative to the hand that they were dealt? Um, and I don't know all the facts. I know that Mark Cohen is an excellent, a very experienced white collar defense attorney, as is Chris Everdell. Um, and I'm confident that they did the best with what they had. I think they didn't have much of a hand to play.
Mm-hmm.
And on top of that, they had a judge who, as we talked about before the trial, was going to keep them somewhat constrained and keep them and the jury focused on the evidence that was relevant to the charges and not let them go off on too many tangents.
When it comes to moving into the final inning here around the closing arguments from the prosecution and the defense, Nicholas Rose, by the way, also a very effective prosecutor, I would say, basically framed this up in three questions he presented to the jury. One, where did the money go? Two, what happened? And three, who was responsible? And categorically walk through all these different, simple to understand examples of where he believes and where he told the jury to believe fraud occurred. I'm curious to get your take on maybe some of the elements of in white collar criminal, closing arguments. The idea of, again, simplifying this down to this is simple fraud, this is simple greed, and using examples that maybe an everyday person would understand in maybe faking a mortgage application details or spending money you don't have.
That's exactly what a good prosecutor does in every white collar case. Um, First rule is to keep the entire case short, which I think they accomplished. I mean, the whole trial was 2 weeks. Um, you don't want an O.J. Simpson type trial. You don't want cases overtried. I mean, the Elizabeth Holmes case, to me, as an outsider, went on way too long for what it was. Wasn't necessary to be that long, and you risk, losing the jury, and you risk overcomplicating things. Keeping it
Mm-hmm.
simple, keeping it relatable, making the point in closing, as the government did very early on, that this is not about some hyper technical cryptocurrency thing. You don't really need to worry about all of the jargon and things you've heard, and to simplify it to basic concepts that people can relate to, and support it with evidence from the trial and the defendant's own words.
Yeah, I gave them credit for that. Yeah, the quote from the closing argument there was, "This is not about cryptocurrency. It's about deception. It's about stealing. It's about greed," which was like a pretty simple and pointing, by the way, to the defendants, which was something out of a movie you had. This is the man who's responsible.
You always point to the defendant.
Is that like rule number one?
That's rule number one. You do it in the opening. If you don't have the guts to stand up and point at the defendant and say, at the end of the case, I'm going to ask you to convict that man or that woman, and say their name and point at them, and do that in the opening and the closing, how can you expect the jury to do what is a difficult thing, to convict somebody of a crime?
Yeah, I guess this is the first one that I've really sat in and seen in person. And it is effective. I mean, it did feel like, okay, the man's calling him out and he's pointing at him. They're like feet away from the guy. It was pretty powerful. When you get into maybe, I guess, again, to the criminal intent, though, that was the piece that was basically throughout the closing argument from the defense, which was you cannot lean into the idea of Sam Bankman-Fried setting up signal messages to auto-delete as proof he is guilty, which is what the prosecution had said in their closing argument as well. And I do think it is interesting to maybe start to consider how effective the defense is at getting the jury to ask that question of, is this true beyond a reasonable doubt? I mean, obviously that seems like a classic component. If the point is there for the prosecution, I suppose that's the classic corollary on the defense side, is it's got to be beyond a reasonable doubt. But what do you make of maybe some of the stuff that the defense is trying to present as, you cannot connect this dot with that dot and say 100%?
That's what defense counsel are left with as an argument. I mean, we talked about it before the trial. I think I said, you could pretty much stipulate to all the facts, and the question and the whole case is about knowledge and intent, and that's the case in almost every case like this. I think the defense had to do, from my reading of the closing, I mean, they were pretty light on attacking the cooperators. I don't think I saw that they called them liars. I think that would be tough to do.
They did not. They did not do that. And that honestly, I think, as we discussed before, that was going to be a key component in this case was, can you undermine Caroline Ellison and say, look, she basically said, by the way, she didn't read the terms of service. And it's like, okay, if you're going to be as, hard on Sam Bankman-Fried for being the CEO and not knowing fully what's going on, how are you the CEO of Alameda and you don't read the terms of service on FTX? And I don't know, they left a lot of meat on the bone when it comes to maybe starting to question some of that. And I was a little surprised.
Yeah, I expect that I think they knew it before the trial. Again, something we talked about, that it's tough to punch down on Caroline Ellison, or any of his former friends and colleagues that testified. They're in a tough position, and I guess she didn't give them much room for cross-examination or for attacks in closing. So, they look, the way the whole thing has played out has not been surprising to me.
Yeah.
You read the indictment. Indictments are just charges. You don't know what the evidence is. You don't know how the people are going to present themselves. You don't know how the jury is going to think about them. You don't know what the defense has in their pocket. You don't know what kind of cross-examination they can muster. But, there are two kinds of cases. There are triable cases, and there are what I would refer to as slow motion pleas, where basically the outcome is kind of a foregone conclusion unless something very surprising happens along the way. And you're just kind of stretching out over a couple of weeks a determination of guilt. And
Yeah.
and look, I always was open to the possibility that the defense would be able to do something with the witnesses, that they had other evidence and the like. But just superficially on the face of it, this indictment read like what we were going to see at trial was more of the slow motion plea, where, they might score a couple of points here, score a couple of points there. But there was going to be so much evidence, both in terms of witnesses and documentary evidence and his own prior statements. And then he gave them a gift, I think, because he had to, of testifying, and then they were able to rely on that as well, that it was going to be just too heavy a lift for the defense to overcome.
At the end of it, though, I mean, we were talking about Elizabeth Holmes and the idea of some of the things that may have surprised you in that, again, not surprising if you're so far behind that your client takes the stand and testifies there. But in that estimation of maybe potentially the outcome could be better, given the fact that the government never discussed a plea deal with Sam Bankman-Fried, what you make of maybe how far the ball has moved in that slow motion plea deal now on the other side, let's say, given he's convicted here on a majority of the 7 counts, whether or not that could eventually be a better outcome for him than what was there prior to the trial.
I think I followed the question, and I think he would have been, if what happens is a relatively quick conviction verdict, probably on all counts. I don't think he's better off for having gone to trial and having testified. Because, at least if he had just pled guilty straight up and put together an amazing sentencing submission, an accepted responsibility, and all the rest, all of that would be taken into account by Judge Kaplan when it comes time to sentencing. Going to trial, it's your constitutional right. You can't be penalized for it, but under the sentencing guidelines, going to trial as opposed to accepting responsibility makes a difference in what the sentencing guidelines say. And taking the stand and testifying, if the judge thinks you lied, that increases, again, under the sentencing guidelines, what the advisory sentence is going to be. And as a practical matter, it affects the judge. And the judge is going to be harsher on somebody who, not because they exercise their constitutional rights, and certainly not in a close case, but if a case is a runaway, and you go to trial and you take the stand and the judge thinks you're untruthful, you're a lot worse off than if you just pled straight up to begin with. Now, this isn't a criticism of the defense counsel or the defendant. We talked about this prior to the trial as well. This case was probably just too big for him to do that. It was too big in terms of the potential sentence he was looking at. He's a young man, and too big just reputationally, just in terms of everything. It's just too big.
Yeah.
To just swallow it and say, I did it, I'm done, sentence me.
Yeah.
That's
No, it's true.
It's hard for anybody to do, but it's harder to do when you are looking at realistically a sentence probably in the 25, 30-year range, if I had to guess.
Yeah.
If he is convicted, um, than in a case where you might be looking at a maximum of 5 years, which, look, a day in prison is not
Not something
something
anybody wants. That is
you
true.
want to get close to. But
Yeah.
you
I
know,
mean, this
it's
case has attracted
uh,
Damian Williams. He's been around he's been in there as, the U.S. District Attorney for SDNY. He's been watching this play out. They've brought out all the big guns. I think they've executed this case very well, and it's attracted a lot of attention, obviously, as you'd expect. But what has been in the back of my mind, and it's something that the defense pushed too, is the idea of the co-conspirators here. Gary Wong, Caroline Ellison, Nishad Singh, and how much, as the defense has highlighted many times, how much their cooperating agreements might dictate their sentencing in all of this. And they say it's not tied to what they deliver as long as they're telling the truth. But as an objective spectator, and I'm sure as the jurors who are watching this all play out, that is a question. Because yes, of course you can say it doesn't really impact their sentencing. But the defense has tried to say, look, the only reason they're here and the only reason they're saying what they're saying is because they don't want to go to jail either. So I'm curious to kind of get your take on the fact that they're facing a lot of the same charges Sam is, what it might mean for them when it comes time for sentencing too.
well, cooperators. Uh, Cases like this inevitably have cooperators.
Mm-hmm.
Why? It all goes back to knowledge and intent, which is the core of any white collar case. And since most defendants don't let one know what their knowledge and intent was in writing, um, you need witnesses to help fill in the evidentiary gap. So cases like this and violent crime cases, drug cases, every kind of case that involves co-conspirators, just about, you're going to have cooperators. And juries all across the country hear testimony from cooperating witnesses every day. And every day, defense lawyers across the United States make the argument that the cooperator only testified to what they testified because they're hoping they get a better sentence at the end of the day. And
Mm-hmm.
jurors evaluate that argument and they evaluate the credibility of the witnesses and the supporting evidence. And every day there are convictions in the United States based on testimony from cooperators, folks who have an interest in the outcome of a case. So uh, I don't know what to say other than it happens every day. Cooperators are, at least in the Southern District of New York, are vetted incredibly carefully. Um, they um, their testimony, their expected testimony, generally has to be corroborated by something,
Yeah.
documents, other witnesses, um, and they
I
have
just
to add
ask,
something of value. And
yeah.
so, look, a lot of it's a little bit of a self-selection issue, I guess, but cooperators wind up getting credited by juries in part because of the work that's done by prosecutors before they sign somebody up to a cooperation agreement. They know what's coming, they know what the defense arguments are going to be, and they want to make sure somebody has fully accepted responsibility for everything
Mm-hmm.
they've done, that what they have to say is plausible, credible, and supported by other evidence.
Yeah. I mean,
And only when they pick,
I just ask because some people are out there floating that because they cooperated, they're not looking at any prison time, which surprised me because it doesn't seem like that would be realistic.
that's quite realistic. Practices differ across the country, but in the Southern District of New York, if you don't have a criminal record, if you are a cooperator, if you testified credibly in front of the judge who's going to sentence you, if the government writes a letter, as they will, to the judge explaining what the meaning of the cooperation was and how it helped them build a case against others, um, very often defendants that would otherwise be facing 20, 30 years may wind up with probation. No
Interesting.
jail.
Okay. Well, as we approach, we've been talking to you about this case, obviously all your expertise when it comes to financial crimes, white-collar defense, and of course, taking down Bernie Madoff. We have gotten great insights from you, and now I suppose as we approach the final verdict from the jury potentially within a few hours, I'm curious to ask what you think the odds are going into the final chapter of guilty, not guilty.
You got to have guilty, not guilty, and hung jury.
We'll add the last one in there, I suppose. Yeah, how do you see the percentage breakdown?
Probably 90-0-10.
Oh, 10's a lot higher than I would have guessed.
Well, it's 10 or less.
We'll hedge.
Look, juries, you can't predict juries, and all it takes is one to have a hung jury.
Yeah.
So you're going to have 12 jurors, and there is always there's always a possibility of a hung jury. I mean, 10, you say that's a lot. I mean, 1 in 10, that's not a lot. But
it's a 10th percentile
1
chance.
in 20, it's something like that.
I mean, we'll be watching. We will see.
But I wouldn't say any different there's nothing special about this case that's telling that's the reason why I'm saying 10%. Or less, but it's somewhere between 1 and 10%. I don't want to get too.
No, it's true. Well, look, I mean, as you previewed for us when we brought the exclusive defense documents from SBF's camp to you, you kind of again went through everything and every possible permutation for what could happen at trial. As I said, a lot of that played out correctly to the way you saw it playing out, and I just want to thank you again for taking the time to sit with us, to talk about the defense, to talk about the trial, and now, again, pontificate on what could happen as you've been generous with your time. Marc Litt, former lead prosecutor against Bernie Madoff, one of the best in the biz, shall I say, in the legal profession. I appreciate you taking the time to chat with us on Coinage, sir.
Thanks so much. Appreciate it.
Appreciate it, man. All right, I think we got everything we needed there.